Well, hi everyone, and welcome to our final webinar as part of Smarter Legal Week, where we take a look at the topic of a members fund guardian within an SMSF. Now, I'm joined once again today by Chris Hill. He's changed his inherent hat. He's got his Hill legal hat back on again today. But what we wanted to do, Chris, and I guess in the context of the title, we were a little bit controversial in terms of the title here compared to maybe some of the other ones, but we called it today why every SMSF should have a fund guardian. And the idea behind today is to really articulate where these benefits actually lie in the context of developing a fund guardian. So, Chris, I might get you to maybe elaborate a little bit more before we get underway.
Yeah, I think that we're working on the assumption that our viewers are their client's trusted advisor. And if you have got a short or even particularly a long-term relationship with your clients, we would encourage you to discuss with your clients about appointing you as a fund guardian. And we'll, as Aaron has mentioned, unpack the benefits of that and how that works. But it's all about you showing value to your clients about being part of their journey during their life, particularly during a period of incapacity, which we spoke of yesterday, but also during their period of when they've passed away. We know that a lot of disputes arise, and as we'll discuss in a moment, it's really important for you to be part of that process and be part of that role. And I'm sure that your client would want that.
But given that you've done so much of the strategic work to get the fund to the position that it would have been in at that very time.
And I think this underlies the features of this Smarter SMSF deed, Aaron, and that it's alive, it's a living and breathing document,
Yep.
And it's designed to empower advisors to offer quality advice and quality services. And
yeah, absolutely. So just, I guess, some context around what we'll be covering today. We're going to be really drilling down on what that fund guardian role is. You will have, for those of you that have been to the sessions throughout the week already, you would have heard us referencing that concept. We would have just touched on it. But for those of you that might be joining for the first time, we'll help you to understand it and where it fits in the context of the Smarter SMSF deed and what its application actually means in the context of your SMSF clients. We then want to be able to highlight to you, and we'll do that through a number of examples as well, the circumstances where the client would look to appoint that fund guardian, your role in playing this and how this differentiates from the role of, say, an enduring power of attorney and the nuances that exist between those and therefore why we've created the fund guardian concept in the Smarter SMSF deed. The benefits ultimately to both the client and to you as the advisor, again, articulated through the relevant case studies. And then we'll show you the actual ordering process within the Smarter SMSF platform and then how you can leverage the Smarter Legal Review to do this as well. So, Chris, I might get you to kick this off about why you think this topic is so important, because you're the one that has a real passion for this when you're talking to clients about estate planning and making sure that they've got their affairs in order from an entire succession standpoint.
Yeah, and we talked a bit more about this yesterday. I think the fact is that our clients are all aging. We're all aging, but our clients are aging, and the families are more diverse. We've got 6-member funds now. There's more members in the fund. We're seeing more disputes within families. In fact, myself and my practice deal with a lot of family-related disputes, and we're seeing more now in the SMSF area. And so we think that really the advisors should be looking at their clients more holistically, including looking at their estate and succession planning. And the idea of the fund guardian is to help you deal with and manage the complexities of your clients and their affairs. The reality is that you will have these clients, as we're going to talk about, in your client books, and the clients are looking to you as perhaps as part of your best interest duty to address these sorts of issues.
Yeah, and I think the other thing that's just worth noting there is that it, in SMSFs, we have a real specialization in this area now, and therefore, when we think about ways in which we can service our clients, there is far more opportunity now that sits within the ecosystem ultimately, which is our SMSF industry, because it may be audit and it may be compliance related and it may be estate planning and there may be actuarial or investment work. There's a lot of intersections that join in here, but the SMSF specialist really in that trusted role needs to be able to understand all the different prongs that exist within that SMSF landscape and have levels of expertise that they can go and apply to their clients as well. And this issue, as Chris, you highlighted before, and again, we spoke about this in the context of yesterday's session, is we do have a far more diverse client base. The fact that we've got much younger SMSFs than maybe when we started 15 and 20 years ago, and much older SMSF clients that have got funds that have been around for a lot longer than they ever have before. So therefore, the diversity of issues become even more important. And for those of you that have had long-term relationships with clients, may have gone through over time issues of incapacity and death and the lessons that can be learned throughout that process. And this is where ultimately this fund guardian has landed, because we recognize the shortcomings that exist within things like enduring power of attorneys as well. So finding that balance in the relationships and then what you can do with that is part of why we started looking at the deed and then the documents that can support you and add value to your clients ultimately as well. And that is front and center of a lot of the stuff that we do to allow you to capitalize on these opportunities that you actually have with your SMSF clients. Well, Chris, let's get into the actual role itself. And I might get you to talk to the practical but legal steps that come along with the creation of the fund guardian within a self-managed super fund.
Yeah, so the fund guardian is a person who's not normally a member of the fund. So typically we've focused this on the advisor being the fund guardian, not necessarily the fund advisor or their company, their business, so that there's a succession plan within the business in terms of holding this role or this office. But the idea is that the individual member appoints the nominated fund guardian as their fund guardian in respect of dealing with their superannuation interests either during their life, during a period of incapacity, or during a period of death. Now, we focused yesterday about the period of incapacity, which is where the SMSF enduring power of attorney sits and where the fund guardian will play a specific role. But but today's discussion is more in the broader context about the role of the fund guardian, even during the life of the client. And this is really ideal for clients who are, maybe are in their twilight years and they're not incapacitated, but they do want that level of support. And even during a period of moving into incapacity and beyond, during the other side, when they've passed away, wanting somebody, their trusted advisor, typically viewers, to help them manage that process on death, their death benefits.
Yeah, so Chris, the other one that I see quite common here then becomes when that dominant trustee has become incapacitated or died, and there's enough assets and the mix, so value of assets and type of assets within the fund that still warrant and justify the continued operation of the fund. But in some respects, the operation of the fund is quite daunting for that surviving spouse who doesn't necessarily have the same skills and acumen to be able to run it that dominant trustee ultimately did. So the guardian then enables that level of proofing and future proofing of making sure that all the things that the incapacitated or deceased individual was trying to do, and it maybe been working with you for a long period of time, will ensure that those things continue on as things move forward as well.
Yeah, it's it's most often the LPR who steps into the role of replacement trustee on the death of a member is usually a spouse or maybe a child who may not be familiar with the rules of the fund, the assets of the fund. And as we discussed a moment ago, there's a lot more wealth than with the fund now. We're seeing more limited recourse borrowing loans being paid off, more equity in the fund. We're seeing diversity of asset structures, cryptocurrencies, shares, listed securities, properties. And so we see the advisor as being very, very important to guiding the LPR, the spouse, in how those death benefits are managed, whether they're transferred in specie, sold, and the timing of those transactions.
Yeah, absolutely. And whilst we initially sort of spoke about that guardian role being an individual, equally that guardian can be not only an individual, but could be done at a business level or in essence, a corporate fund guardian. So just get you to articulate the differences between that, noting that Rule 26 of the Smarter SMSF deed sets out the role, the appointment, the role, the removal, all those sort of elements that are fundamental to the fund guardian's operation.
Yeah, and so you could potentially have a corporate fund guardian, like the business entity being that. And this would be suitable for large practices where employees come and go. It's important that the client stays with the firm, so to speak, as you would expect when people come and go. So, for larger practices, they may want to appoint their business or their corporate, the entity that owns that business as the fund guardian. Especially where there's a lot of wealth and there's and this is ideal for like accounting and financial planning practices where there's accounting and administration work with financial planning work. It might be important for the client or the fund guardian to be the practice principal or the practice entity so that there's continuity of the management of the affairs of the client during a period when the client either loses capacity or when they pass away.
Yeah, absolutely. So when we think about the role of the guardian, there is, I think, the important part here when we distinguish between an EPOA and a guardian is that the guardian's role here is limited, and is limited in scope to really vetoing decisions that may be being made in the fund that could be perceived to be detrimental to what the instructions of that incapacitated or deceased member may have wanted to occur. So Chris, can I get you to sort of elaborate a little bit more on the function of the guardian in terms of this vetoing power that it has or builds in?
Yeah, and I think in the process, I think for those of our viewers who attended yesterday's presentation, I think it's important to try to make clear the distinctions between the SMSF, enduring power of attorney, and the role that the fund guardian plays there, with a non-EPOA and just the appointment of fund guardian. So the fund guardian's role is, as you can see here, is a veto or essentially a consent power. So when you create the document, Aaron will speak to that a bit later. When you create the document, you can list those powers or functions that requires the consent or of the guardian. With an SMSF power of attorney, we go a step further and we create what we call prohibited powers and express powers, as well as these consent powers, as well as we put the guardian into to carry out other functions like determining capacity and making a decision around those sort of issues. So the SMSF enduring power of attorney is a more special purpose document where the fund guardian plays a more specific role. Here we're talking about the fund guardian having a more broader role, which can operate during a period before incapacity, or during incapacity, or during death. So that has a more general role for the available to the guardian, and it's a consent role.
Yep. So I might actually quickly jump across. It's probably as good a time as any to get into it. So I've got again, we're on the Smarter SMSF platform here, and I've created just a saved order to save some time in terms of the population of the information. So what we have in this instance is our appointing member. we have the relevant guardian here. So I've gone forward. I might just go back a page first just to explain what's happening at the beginning. So we're in essence capturing our fund information. We're capturing the trustee detail, who the directors are, the chairpersons for the minutes of meeting, and so forth. So all the standard information that we'd ordinarily collect throughout that process. And again, we can drag this information in from relevant software that we see fit. We have who the member is that's looking to appoint that guardian. We have the number of guardians there in this instance. We haven't at this stage built a corporate guardian into this, but we will certainly be looking to do so. But then, as Chris was saying, it comes down to these sort of consent powers or the power to veto certain decisions. So in here, when we look at the role, there's a number of questions that are being asked. And then these types of items require the written consent of the guardian to effectively approve, or the guardian can stop these decisions being made if they want to, if they don't believe they kind of fit the narrative of what that individual had actually wanted to occur in the first instance. So in the form, you're actually working through and selecting the relevant items in here that would require the consent of the guardian to ensure that that would follow through. And ultimately, as we spoke about in the session yesterday as well, if the trustee ultimately goes off and does something that required the fund guardian to effectively approve that, well, then we do get into a situation where we have a breach of trust. And then there would obviously be a level of recovery that would be able to occur in respect to that issue. So we get to ultimately here off those relevant pieces of information that we just showed you in the form, we then stipulate through that deed of appointment of guardian, all of those relevant items then get added into the specific document there as well. So Chris, let's sort of jump in now and start to highlight some of the differences as to why the guardian role was born when we compare that ultimately to an enduring power of attorney that we know sits within section 17A3, 2, 3. Well, 2 and 3.
Yes, both. All right. So, so in the case of an EPA, where we're talking about the replacement trustee, we're talking about the person who is going to replace the member when they lose capacity to ensure that the fund meets the definition of being a self-managed super fund, its complying status. And of course, when the EPOA steps into that role, they have full control. They have all the powers and functions of the member pursuant to the terms of the deed, including the voting power. So in that sense, we say that they have full unfettered control subject to the deed, but they're not fettered by the terms of the EPOA. A lot of people mistakenly think that if they put clauses into the EPOA document, that will somehow regulate the decisions of the EPOA when they become trustee. That is completely wrong, because they are performing a different form or office. They're now trustee. They're not an attorney anymore. That they step out of that role into a new role. And in fact, the member steps out of the role of trustee. So they're replaced, whether it's a director of a corporate trustee or individually. And of course, what that means then is, and as we discussed a bit yesterday, there is the potential for conflict between the EPOA and the other member. And it could be typically people appoint their child, if it's a step family, maybe their eldest child, as their EPOA, particularly when they're thinking about what happens on death, because they think about, and lawyers talk to clients about, a transition process. And so if there's a division of assets between a spouse and children from another relationship, they will usually be appointed as the EPOA, but that can lead to tensions and conflict between step parent and step children as members of the fund and as directors of the corporate trustee. So the idea of the SMSF EPOA is to regulate abuses and control the decisions of the trustee when they step into that office. So that's the SMSF EPOA that we talked about yesterday.
Yeah, and I think what's worth noting there, which we touched on, is making sure that we understand those nuances, and we can see on the right hand side here the fact that when the client, you're talking to the client, you do have that long standing relationship. The client comes and asks you, oh, well, could you maybe step into that role as my enduring power of attorney? And the reality is that there are so many layers of restrictions in doing that, whether you're an advisor, so you might have some obligations under your AFSL, you may have some obligations under code of conduct ordinarily, but probably the most likely thing will be the fact that you can't charge a fee. So, we look at our definition of a self-managed super fund, and it is abundantly clear that when we look at what the requirement is as one of the four limbs to the definition of an SMSF, is that trustees cannot be remunerated for trustee services. And this is and fits into a trustee service. And I think, Chris, the other one that we touched on yesterday was just as we kind of go down the left-hand side there, the fact that, the issues we have with the definition of when someone suffers legal disability as well.
Yeah, well, there is no, in the context of incapacity, in this context, mental incapacity, let's put it that way, there is no clear definition either in the SIS Act or in any other authority other than the relevant state powers of attorney acts. So, when we're talking about the intersection between Commonwealth legislation and state legislation, for the purposes of the SIS Act, what definition do we choose? Right? So, which is why we've developed the SMSF, the special purpose SMSF power of attorney. We've sort of settled that position with coming to a definition. But beyond that, we have this issue of the intersection between when a person has to be replaced and at what point of their disability are they incapable, or do they suffer from a legal disability? That's clearly not defined.
Yeah.
And if someone's had a stroke, well, it's very clear. But if you've got dementia or Alzheimer's, it's a transition process. And at some point, where do you draw that line?
Yeah. So the really good questions come through. So it says in the context of EPOAs, so why do lawyers allow, in essence, EPAs to be drawn up with restrictions if they're not allowed to be applied? Is this not giving the member a false sense of security?
Well, that's a good question. But of course, we need to be mindful that EPOAs weren't designed for the SIS Act or for self-managed super funds, right? They're created under each state and territory legislation for the purposes of dealing with all of the client's assets, so their house, non-SMSF assets, right? Because we've got this state and federal jurisdiction, they don't talk to each other. And the SIS Act hasn't really given much thought to this issue, which is why we have this problem. And lawyers who are drafting powers of attorney really don't think about SMSFs or superannuation funds for that matter. Are thinking about non-super assets, which is what...
And then it comes back to the legislation, and the legislation is well, you need an enduring power of attorney to allow for them to step in, but actually it doesn't give any consideration to the fact that the individual that holds that EPOA is now a trustee of a trust of which that member is a beneficiary, not specifically to the assets that were owned by the member themselves that are outside of the trust, i.e. the SMSF.
Yeah, and essentially what the SIS Act has done, it's just created a doorway to say, okay, whoever's the enduring power of attorney, and that's not defined, right? It just says enduring power of attorney, but the presumption is that it's an enduring power of attorney made in accordance with the relevant state legislation. Once you find one, then they just come into the door and we shut the door, so to speak, and then they're governed by the SIS Act and because they're a trustee, right? They're just regulated by the deed and the regulatory requirements under the SIS Act. So, but of course, coming back to our earlier comment, you then give complete control and unfettered discretion well, not, it's vetted in the sense that the terms of the deed, but if you've got a member who's got the largest account balance, right, and can make all the decisions, suddenly you've got a son or a daughter who's not a member of the fund, probably knows nothing about SMSFs, now being led into the fund because they had that hat, I am an EPOA, and now they can completely control the assets of the fund.
Yeah, absolutely. And that becomes important again, where you might have joint attorneys and where you only decide to appoint one. And the ATO has effectively confirmed this as well with some guidance on their website, that if you have joint attorneys and you only appoint one to come in to step in as trustee, that does satisfy the requirements, because using your analogy, Chris, before about, the EPOA opens the door. Well, it doesn't, the ATO is not concerned whether it's one or more, as long as that one has come in and then the door shuts again. And as you said, that person now has all the rights and responsibility that comes in with being a trustee or director of the corporate trustee, potentially, or not potentially, to the exclusion of the other person that was maybe, or persons that were appointed in a joint attorney sense.
Yeah, and I think the ATO in that ruling has said you can either have one or both, right?
Yes. Yep.
Now, most powers of attorney are drafted on the basis that they appoint joint or joint alternate. Now, of course, if you've got joint alternate, how do you decide of those joint or alternates which are going to step in, or if they all step in? And if they all step into the fund, if they all say, no, we want to be involved in this decision making, how do they exercise the decisions of the member? Let's assume that the decisions of the member is based on account balance. How do they exercise the decisions or the votes of that member? Is it jointly? I think I would assume jointly. What happens if they can't agree? What happens if one child, for example, the stepchild, let's say the stepchild and the stepmother to become the joint attorneys? What happens if the stepchild says we should sell an asset and the stepmother says, no, we shouldn't? How do you reconcile those differences? There's a lot of issues with a standard power of attorney. That's why we've developed the special purpose power of attorney. There's a lot of issues there to be navigated.
Yeah, and to some extent, it doesn't really matter whether you've got, dollar of account balance or one each. If you've got three people in there and they have one vote representing, if they can't agree, they can't agree, and you've got yourself a problem.
You have, and you'll have a problem somewhere.
Yes.
Because somebody won't agree, and the majority will outvote potentially the other member.
Yeah, correct.
You've got two attorneys.
Yeah. All right. Well, let's sort of move now a little bit more into the role and the powers here. So specifically, as we said, Rule 26 looks to this issue that provides, as we've already highlighted, something that is much different and broader to what you see in an enduring power of attorney. Now, how and when that appointment of the fund guardian is very much up to the decision of the individual. So the fact that you can, as part of that decision making in the ordering process, choose whether it is to effectively commence immediately or it is to commence at a point in time where they no longer have capacity. So there are a number of questions that ultimately go through in that form, as we touched on. But as we stipulated earlier on, Rule 26 here sets out the entire process in terms of how that operates. And I know, Chris, we made a couple of adjustments at the 1st of July this year. I think most of them really sort of tied in the SMSF enduring power of attorney as well. But I don't know if you wanted to sort of update on anything else in respect to the rules specifically and the role and power that we're sort of talking about here.
No, we obviously added, we did add rather from the 1st of July, the ability to have a corporate fund guardian. We didn't have that previously. And for all the reasons we've discussed, but also for the succession planning, like what happens is that clients are clients of a firm for many years. The advisors have been the advisor of the client for many years, but they want to retire, right? Or they pass away themselves. So this was about providing succession planning for the business in the role as fund guardian. But I think there were the main changes to sort of link the fund member's guardian to both the new special purpose SMSF will that we've developed, a special purpose SMSF power of attorney, and of course for the corporate fund guardian.
Yeah, and we had a question yesterday, and I think we've got it on the second last bullet point there, that the guardian's role can only be terminated by the member and not the EPOA or the trustee. So again, these are sort of questions that you'll be discussing with your client and maybe getting some guidance along the way as part of the legal review. But effectively, there are some important functions that we need to think through and talk about with our client in developing this fund guardian. So crucially, as we've already highlighted it, the guardian does not replace a trustee. So it falls outside the definition of an SMSF. And when we develop the Smarter SMSF deed and have for a long period of time, we know what sits within the superannuation laws broadly, and that can encapsulate the income tax laws and so on and so forth. But there's nothing that prevents or precludes us adding layers in to a particular area. And what I mean by that is that if we want to put in a fund guardian, or if we want to put in some form of restriction around how a pension can be paid, as long as we're complying with the core elements of what the superannuation laws set out, well, then we can actually introduce additional things. And we do that by these various documents that we create and then adopt these as a special rule of the fund. So the most important part of this in the role of that fund guardian is not only that trusted advisor status that we were talking about before, but you then come in as the advisor and can still continue to do what you're doing and can charge the usual fees that you would do as well. And again, those are elements that sit within the questioning that is done. But Chris, I think there are some practical things that if you are going to move into the guardian's role, that the scope of the work that you might be doing as the advisor arguably changes as well. So maybe if you could highlight what some of those things might actually be that you've seen in practice.
Yeah, well, certainly the scope of work might be extended certainly beyond the death of the member. Quite often, it's unclear for advisors when their client passes away, does that terminate their engagement, right? Depending on the terms of the engagement, though, but it typically terminates on the death of the member. This is an opportunity to extend that scope beyond the death of the member, as the member would probably welcome. If there's potential conflict in the family, or if there's an EPOA that doesn't have the financial acumen to deal with the assets of the fund, they would certainly want their trusted advisor, I would think, as being a fund guardian. So that scope would change in that role. In the case of a conditional pension, sometimes known as a restricted life interest pension, the guardian's role or the advisor's role may be to become a member of the fund. The deed allows you to become a member if you want to. If not, just to monitor the activities of the pensioner, in relation to the payment of a conditional pension. So that will broaden the scope to maybe just doing accounting and financial advisory work. But what it does is it provides a lot more. I think it changes the scope of the advisor from just being seen as a financial advisor or an accountant, but being a trusted, lead advisor in managing that client's wealth and connecting it with the next generation. And that, of course, provides the opportunity for you to continue those services into the next generation with as your new clients.
Yeah, and it comes down to, if we think of a conditional pension that you spoke about before, and I was kind of using that reference earlier when I said, well, a conditional pension is in essence an account-based pension, but it's got additional layers added to it that help with things like blended families. There are additional practical things that then need to be introduced into that to ensure that there is a limitation around how that pension will operate, that they don't try and use portability rules to move it out, because they are in essence signing off as part of that conditional pension that they're agreeing to the terms of that, and that they won't do those things as part of being entitled to the receipt of that particular amount. So again, it provides not only an opportunity to be talking to your clients about this, but then looking at the scope of the work that's being done, either continuing to charge what you are charging or arguably even increasing that as well. So I've got a couple of other questions coming in, and one that Deborah's asked here is around how the existence is noted in the deed or EPOA about the role of the guardian. I think this slide is important to talk about where the guardian document actually fits in. So Chris, we spoke about this in a bit of detail yesterday, and I might get you to highlight the importance of these two definitions that we actually have within the deed and why they actually sit there. And it ultimately goes to answering Deborah's question to see how these documents actually connect in and why you actually need the Smarter SMSF deed to do it.
Yeah, so the idea of the concept of a special rule is to effectively hardwire the provisions of either the SMSF enduring power of attorney, or if it's just a fund guardian deed, appointment of fund guardian, into the rules of the fund, and whatever is in the terms of the fund guardian deed become a rule of the fund.
Yeah,
right?
so Chris, and I should just say there that there are a number of things that can become a special rule: pension documents,
Yeah.
death benefit nominations,
Yes,
a whole raft of things. But ultimately, what you've just said is that document is allowed to be prepared in accordance with the rules of the fund, but we want to annex it in as if it was hardwired into the deed itself.
Yeah, so the idea, to sort of come back to Deborah's question, is that with the fund guardian, we hardwire that into the deed, as we say, and the deed can't be changed other than with the consent of the member affected. And by making it a paramount document, we're saying that this document will override any other document as part of the administration of the fund to the extent there's any inconsistency. And so what we're trying to do here is deal with the mischief that could occur with a new trustee who comes into the fund, a new EPOA, deciding to change the rules or to sell assets or to commute or roll over. Now, we've gone one step further with the SMSF EPOA, because remember, this now then speaks to the actual roles and functions of the EPOA when they become the replacement trustee. We go further with that, and we create more functions as far as the guardian is concerned about, when they can come in and when they leave. Like, for example, determining capacity. There's a process in the SMSF EPOA for that purpose. But at this level, in terms of the general level, the fund guardian can come in now, can come in during a period of incapacity, or can only just come in for the purposes of the payment of a death benefit. So it has a much more broader application. And to the extent that this is a special rule, it can't be changed. Their decisions, if it's a consent power, can't be overridden by a power that the EPOA may have by virtue of the account balance, right? So because it needs the member affected being giving their consent, and that consent cannot come from the EPOA. So it's designed to stop the abuse that could occur, which is the mischief we're trying to address, from ineptitude or from fraud.
Yeah, absolutely. So we just might have a quick look at our sample document that we've got here. But effectively, we go through, and in the document itself, we go through and identify the fact that it is to become a special rule of the fund. And Chris, you might know it off the top of your head better than me where we might find it. But not only are we getting that document signed off, but then you can see here there is the request to add it as a special rule of the fund as well. So there are the relevant steps that are being taken, both in the deed that is prepared, and then the fact that the resolution occurs, the request by the member to say that it is to be added as a special rule. So those two parties to the agreement, the member, and then the trustees themselves saying that Rule 1.8 allows for additional rules to become a special rule of the fund where declared, and where relevant, it would be deemed to be a paramount document as well. So you can see there then the notification back to the member that affirms that has been now established as the special rule of the fund too. And we've
Yeah.
built a guide that really works through how 26 works and put additional sort of meat on the bone when it comes to the role and the case study and so forth as well. So it is quite comprehensive in terms of the guidance that you've got. And then if you want to obtain any sort of legal review off the back of that, then you've got Chris and his team there to be able to support you around how that works as well. So Chris, we've got another question here, and this is probably for a bit of both of us. When seeking the approval of the Guardian, so we have our Guardian document in play, does Smarter SMSF have any plans to create some form of approval template? Or two, so one is, yes, we will. And I guess, Chris, you've probably done a little bit of work in that space as well. So we would certainly be looking to add those items. So if someone is looking to undertake something and the fund guardian is in place, and there is some sort of consent power that needs to be given, it would be quite simple to create a template that in essence has the guardian approve that decision, and obviously documenting that is crucial. Or will the approval by the guardian be obtained within the underlying document, i.e. the pension commencement would then be signed by the member trustee and fund guardian? So Chris, I'm not sure what your views are around that and what you've sort of done in practice so far.
I guess, I suppose we're looking at approval at two levels. Are we talking about the approval of the guardian itself or the decisions of the guardian?
The decisions of the guardian here.
Yeah. So in the SMSF, during power of attorney, the special purpose one, there are decisions that have to be made. If there's more than one guardian, for example, has to be made unanimously. And there is a dispute resolution sort of process if they can't agree, particularly around incapacity, right? What we're trying to do, or capacity, for the purposes of do we meet the definition of a legal disability, we've sort of developed that process so it makes it a lot easier. There is a sort of a process built into that. But essentially, for our viewers, we're talking about clients who want to appoint a trusted advisor to make certain decisions that they're, comfortable, that requires them to sort of say yes or no, right? And we provide that checklist when you order the document, as you shown a moment ago. So whether that's a template that's been referred to in this question, I'm not sure, but it looks like it to me. I guess perhaps the issue behind the question is, well, look, what would you recommend would be these powers? And it may be that a more bespoke set of restrictions or consent powers may need to be applied depending on the fact situation of the client. And every client is unique, particularly if they've got unique investments, if it's cryptocurrency or they've got blended families or family tensions, or there's issues around, aged care, as we'll touch on in a moment. So that's where a more bespoke process might be required and where the bespoke service is available.
I think the other part of it, Chris, is, so if the guardian needs to, in essence, approve it, I think my preference would be that you would have an additional document. So using the pension commencement there, would it be signed by the member and the trustee? But that decision to start a pension or a commuter pension also needs the consent of the guardian. I would probably then have some other resolution that then says that this is intending on being created upon execution, and it would require the consent of the guardian, and the guardian hereby consents for the commencement of the income stream upon execution by the relevant parties of that document.
Yeah, it's getting that third party sort of sign off.
Yep.
And look, it's not, this whole concept of a fund guardian is not unfamiliar. I mean, we see it a lot in family trust deeds, where a fund guardian or a guardian is required, sometimes named differently, but person's name before you can change the rules of the fund, you need the consent of the guardian, or to exercise certain functions, vesting of assets, for example. So we've expanded that role into the SMSF, and it flows very naturally because the SMSF is a trust,
yeah,
by its nature.
Yep, absolutely. All right. Well, obviously, in terms of the benefits of a fund guardian, I think we've probably highlighted a lot of this as we've gone along, but we see a range of areas that quite clearly can be beneficial for you to be exploring this concept with clients. So whether it be your aging clients with much larger account balances, in particular with things like excess transfer balance amounts and even the introduction potentially of our Division 296 tax. We've spoken about blended families or even families that have conflicts in them, whether it's through a range of factors of spending, disability, other at-risk sort of issues as well. We also know that there are those that may be down as the last surviving individual and there's no other sort of surviving relatives or children there. We want to sort of put in place with things like blended families, conditional pensions, any and all of those things certainly are areas that you could be exploring this concept with your clients. But equally, as the title of this entire session sort of is that you will be able to find almost in all circumstances a way in which the fund guardian could apply in virtually all of your SMSFs. Mm. So I guess let's keep moving because I am conscious of time. We've spoken here about the benefits of the guardian's role. So again, I won't spend a lot of time talking through this. We do, as a concept, also within the Smarter SMSF deed, talk about the concept of an SMSF living will, and to some extent, Chris, the SMSF power of attorney that you've done sort of fits the narrative somewhat here. So I'm not going to sort of jump into Rule 10 specifically, but what I did want to spend a little bit of time on here before we go into our examples is just to look at this table and really delineate between the different functions that we've got here. So I might get you just to try and summarize it to give people that understanding of why you might have the different elements in here that we've been talking about, not only today, but in the past few days as well.
Yeah. And look, I see this as a bit of a transition process, but as we said earlier, the fund guardian is really to provide supervisory oversight of the decisions of the member, either during their life or during an incapacity or upon death. So it has a much broader encompassing role, and that's obviously suited to advisors who have long-standing relationships with their clients, and have a trusted relationship with the client and may have a lot of wealth and have conflicts in their family. Really well suited to those sort of circumstances. The SMSF living will is essentially a will that you can create that deals with what happens with your member benefits during a period of incapacity. It doesn't apply on death, right? So it's probably, it's another step further from the EPOA, and we can certainly scope that out into one document, looking at it in the future. Classic case, and I think it's coming up in one of our case studies, but in the interest of perhaps time, but we can just mention this, that if you've got a client who says, look, if I lose capacity, I want to go into this particular aged care. The RADs are $1 million. It's really, I really want to be in, or my husband went there. I want to be there with him, right? But I'm just concerned that my kids might send me over here. I've got plenty of money in my super fund account, and that's where I want to go. So the member can write those intentions into an SMSF living will to specify what should happen or the restrictions that should happen on their member benefits during that period of incapacity. And it's maybe just protecting the estate, right? Because it's the same with the power of attorney. What an attorney will do with other non-superannuation assets will impact on what happens to the estate. Assets might get transferred, get sold, distributed. And this is another way that the member can take the same concept into the assets of the fund and restrict them.
Yeah, absolutely. Let's go through and have a look at some common examples now. And the first one here around a single member fund. So we've got Mildred, she's a widow, age 77, and is the sole member director of her SMSF. So she's got no other children. She has a sister that lives in the UK. She has a nephew, John, who's nearby. But Mildred has, while she has some relationship with him, she doesn't really have a lot of confidence in his financial acumen. It's probably the best way to reference it. So she got about $1.25 million in her SMSF, some shares and managed funds and cash. Now, Tony, her accountant and advisor, is the one that looks after her affairs. So she's concerned about what will happen if she actually loses capacity and how her money is then going to be managed and controlled. So Tony's clearly flagged these issues with her, but quite clearly as well, he does not want to be her EPA. So she's looking to him for an answer. And one of the answers is, when you go to the SIS Act, is, well, can we look at an EPOA function? Tony's like, well, yes, we would arguably need an EPOA, but I'm not going to be that person. So the action that we're going to look at here is that Mildred can look to appoint John as the EPA with the power to step into that as a replacement trustee at a point in time where she has lost capacity. So you've got that at that point in time, it's when he's to step in, not at the immediate point in time. But to help oversee that function, Tony has been appointed as the member's fund guardian. And the reason why the guardian is being put in place is that it's giving Tony the powers to veto decisions. So those vetoing powers will ensure that if there's a transfer of benefits, it needs to seek the approval of the guardian around how much is being made in pension payments, what decisions are being made around the fund's investment strategy, if money's trying to be rolled out, if they're trying to add other members in and trustees, and therefore trying to influence decision-making in the fund. That power could commence immediately if you wanted to, and the guardian will operate not only during her life, but then also in respect to the payment of the superannuation death benefit, in essence, where she wants that to go across to her estate. So Tony is appointed executor and LPR of Mildred's estate. So, Chris, is there anything you kind of want to add around that? I guess I might sort of talk through some of these examples and get you to add some flavour to each of these.
Just quickly, and I'm saying this against my profession. A lot of lawyers who deal with the estate just liquidate everything, right? And I've been a financial advisor, and I know from the financial advisor's point of view, they lament that sometimes there's a better way of selling or dealing with assets. Having that advisor involved with whether assets are transferred in specie or sold, considering the tax considerations, the timing of them, is really, really important, because it can, but the lawyer's focus is just to liquidate the assets and distribute the estate. So having a trusted advisor be involved in that process is really important, because once the executor goes to a lawyer to deal with the estate, then the lawyer will take over and just sell or transfer the assets, and that may not be the right decision.
Yeah, absolutely. So let's keep moving along, and let's assume the same facts that we had there with Mildred, except Mildred tells you that she's been diagnosed with dementia and is inevitably going to need supported aged care at some future point in time. So this is where we come up with that concept that Chris was raising before, about where she's made a decision at that point in time where she actually wants to go. So she has decided here, because she's got a friend already at Tea Tree Lodge, that she would rather pay that refundable accommodation deposit. And then what we want to have happen is she says to you, I would like this to come out of my account within the self-managed super fund. So we've got some specific stuff here. So again, Mildred would appoint John as her EPOA. Mildred would prepare an SMSF living will, because there are very explicit instructions that she would want to have. The SMSF living will here would be treated as a paramount document, so that it ensures that it outranks anything there, so that in the event that Mildred loses capacity and needs aged care, there is specific instructions as to what needs to occur. And then that gives her the confidence to make sure that the things that she holds true to her actually get played out that way.
Yeah, and perhaps we could just say that the advisor would be the fund guardian to implement and ensure compliance with this whole process.
Yep, absolutely. And then we move on to more blended family situations here. So we've got Harry and Margaret Benson, the perfect blended family in their 60s, been married for 10 years, got accumulated benefits. We've got children for Harry from a former relationship, and Margaret has 2 children from an earlier relationship as well. We have the situation where Sophie does not get on with her stepmother here. We have the gold digger analogy that's also been made, and we have similar tensions that sit between Margaret's children and Harry as well. So we have a self-managed super fund, the Benson SMSF, and we've got just over a couple of $1 million in it, which incorporates about 50 or a bit more than 50% of it in a commercial factory inside the SMSF. So when we look to the objectives here, we have Harry and Margaret each wanting the survivor of them to enjoy an income stream from their member balance. And they want the capital of that preserved so that the factory doesn't get sold until a later point in time when they have both passed away. And then when they both pass away, they want the account balance to pass to Tina and Sophie, and Margaret, for Harry that is, and Margaret wants her balance to pass to Jonathan and Janet. And they want Peter, their advisor, to ensure that this happens. So Chris, to you, what are the actions that we might look at doing in this circumstance?
Well, we would create a conditional pension, which, as we touched on earlier, effectively just holds the assets in the fund and restricts Margaret's access to, or the survivor of them's access to that asset for the benefit of the next generation. And we create a restricted income stream that is paid in accordance with the pension payment standards to the surviving member. And
there'll be a limitation on that. So it'll basically say it might be $50,000 a year, or if the minimum is more than 50, then the minimum. But that's it. So the minimum is the maximum, or 50,000 is the maximum.
And we can put restrictions on commutation, maybe depending on lifestyle needs. So yeah, the pension payments are the minimum. You can dial it up or dial it down, a specific lump sum, but we preserve the asset. Because obviously, when one member dies, the surviving member can do whatever they like with that asset. And with blended families, we want to preserve assets for children of another generation.
Yeah, absolutely. So, and then I guess the other things that we said, so Peter would be appointed as the fund guardian here, making sure that we've got in place the right steps so that there is not the access to the capital that we were talking about before, and veto any investment decisions that would prejudice the children of each of the relationships earlier from getting what they would ultimately want to get to as well. So, so I'm going to sort of finish off there. I might sort of miss this last example here, and you can go and have a look at it in your own time, because I am conscious that we have sort of hit the end of the session as well. The last thing that I just wanted to highlight is that as part of this process of ordering a fund guardian document, so a deed of appointment, you can naturally request Smarter legal review. So as part of the order, as you can see on the screen here, hopefully you do have that ability to then go through and have Hill Legal actually go and undertake a review of that to make sure, again, that it complies with that process. Now, Chris and I have been having ongoing discussions as to where this fits, but ultimately, if we have a fairly straightforward document off the back of an existing Smarter SMSF deed that doesn't have any sort of limbs that sit off the back of it that might be 5 or 6 or 7 deeds old, then it should be a fairly straightforward process that would need to occur. Again, otherwise, it might fit into one of those other categories. So, Chris, I don't know if you wanted to sort of just add anything on your side there from Hill Legal's point of view in signing off, in essence, what would be a deed of appointment of a fund guardian.
Yeah, well, I think even if advisors are not sure, because I think that where we might land today with people saying, well, do I need a SMSF POA or normal POA or fund guardian? If you have uncertainty, we've created all these tools for you with the provisions of the deed to deal with all these different family scenarios. So if you're not sure what is relevant, please reach out to us.
Yep.
or Aaron and his team, and we'll guide you through that process, because I think that's really important. And
Yeah.
of course, when you're seeking a review of a document, give us as much factual information as you can, because that will help us scope it. It might involve a discussion with your client. It might be a very simple review, and it's like, okay, we would encourage all advisors, if you are a trusted advisor, to discuss this with your clients across the board, right? As a default position. Why wouldn't they want you involved if it's going to avoid dispute? And if there's any tensions in the family, you should certainly single your high net worth clients, or clients with splendid families, or clients with conflicts, and you'll know them, and you should introduce this. And if you've not got sure whether we should be doing an EPOA, a general EPOA, a special purpose one, or a fund guardian deed, just reach out to us.
Yep, even SMSF will. But I guess importantly, when you go along those 4 different areas that we've sort of highlighted this week, they can all be done ordinarily under the Smarter SMSF deed, but as a solution under the Smarter Legal Review Service and what we've built with the work that you've done, Chris, at Hill Legal and Inherit, we can ultimately achieve the outcome that you're looking for with your clients as well.
Yeah, and just quickly another plug for Inherit, that this is really about providing an estate planning, a continued estate planning conversation between you and your client. So some of these issues might fit into that estate planning conversation, around the transition of losing capacity, passing away, whether it's an SMSF will, living will, whatever, that might be part of an estate planning conversation. That facility is available through the platform.
Absolutely. Well, that takes us to the end of our Smarter Legal Week. So thank you, Chris, I guess, first and foremost, for joining me for all of these sessions, for taking time out in each of your lunch hours that Monday to Thursday this week. I hope you've got a lot of joy out of sort of doing this as much as I have in sort of providing this to our members and to our audience more broadly. I think I would argue on our side, we really haven't done enough in this space to sort of showcase, the real power of what we have built collectively within our businesses to be able to support our members and more broadly those that are interested across our Smarter SMSF products and those that we integrate with as well. So these events were designed to showcase what we have and the power of the work that we do within our business and the tools that we have to be able to support you as well. So what we have created on our website as well is that each of these sessions we have recorded and we are putting up under the legal tab, under documents and legal tab, you'll see a Smarter Legal Week. So if you do want to go back and have a look at these sessions or share with others that you think may benefit from the discussions that Chris and I have had throughout this week, please feel free to do so as well. So thank you once again. Yep, Chris.
Sorry, I was just going to say, Aaron, just before we leave our viewers, there may be, we've skirted the surface on these 3 in this area. If there are, if our audience would like more video content about this or more presentations, maybe they could fill that out in the feedback form, because I think that these are really important topics and maybe we need to focus a bit more, and we can do if that's required.
Yeah, absolutely. Absolutely. Well, thank you, everyone. Once again, we might have 1 or 2 final questions here that I'll have a quick look at now. But if you need to leave, enjoy the rest of the day. And thank you for joining us for Smarter Legal Week. Take care and bye for now.